guest can be replaced.
We'll get started for the day. Yesterday we had a great keynote from Professor Schmidt and an opening discussion on the Talon Manual. Also, I'd like to welcome Professor Derek Jinks, our advisor for this symposium. So today's first panel will be on state responsibility for cyber attacks. We have Dr. Marco Roschini and Professor Schmidt, our panelists. Dr. Marco Roschini has a PhD from the University of Rome, La Sapienza, and is currently Reader in International Law at the University of Westminster in London, and Visiting Fellow at King's College in London. Dr. Roschini is the author of 2 monographs, the first on nuclear weapon-free zones, and the second on cyber operations and the use of force in international law. He is also the co-editor of Non-Proliferation Law as a Special Regime. Dr. Roschini was previously a research fellow at the University of Verona School of Law and lectured on the international law of armed conflict at UCL, King's College London, and Queen Mary University of London. He collaborated with the International Justice Project at the International Secretariat of Amnesty International, for which he prepared extensive commentaries on the implementation of the International Criminal Court statute in the Democratic Republic of the Congo and in Italy. He held a Leverhulme Research Fellowship in conduct, to conduct his research on cyber operations. Dr. Roschini is a member of the International Law Association's Committee on Nuclear Weapons, Non-Proliferation and Contemporary International Law, and of the European Union Non-Proliferation Consortium. He is in the editorial board of several scientific journals and book series and is one of the core bloggers on arms control law. Professor Schmidt, who I introduced yesterday, I'll give his introduction.
Haven't changed actually since yesterday.
No,
so.
But our audience might have. So, Professor Schmidt is the Charles H. Stockton Professor and Chairman of the International Law Department at the United States Naval War College. He is also Professor of Public International Law at the University of Exeter and Senior Fellow at the NATO Cyber Defense Center of Excellence. He was previously Professor of International Law at Durham University and Dean of the George C. Marshall European Center. And prior to that, served 20 years in the United States Air Force as a judge advocate specializing in operational and international law. Professor Schmidt has authored over 125 books and articles and is editor-in-chief of the International Law Studies. Professor Schmidt has also participated in numerous international expert working groups and was the director of the group that produced the Talon Manual. So I'll turn it over to Dr. Roschini for our first discussion.
Thank you. Can I speak from here, or do I have to go?
Sure.
Yeah, I think it's more comfortable. Thanks very much. Thanks for the long introduction. I was telling Mike that some things I didn't even remember were in my CV, so it's good refreshing my memory about my own experiences. Thanks everyone at the Texas International Law Journal for inviting me. It's a pleasure to be here, and thanks a lot for your great hospitality. Moving immediately to the topic, because I'm quite famous for not meeting the time limits, so I hope they will not be enforced strictly here, as we have 1 hour and a half after all, right? So I'll count on that, but I'll do my best. So moving to the topic, as you can see, it's related to the evidentiary problems that you face when you talk about interstate cyber operations. Obviously, the problem of evidence is not peculiar to cyberspace. You just have to read the Nicaragua judgment, one of the classics of international law, and you see that in the judgment, the court at some point says that the real issue is not often the legal attribution of the act by finding proof of the identity of the perpetrator. Obviously, the court was not talking about cyber operations, was talking about other type of armed activities. But as you can see, the problem of evidence is was not born with cyberspace. However, it is undeniable that the evidentiary issues are particularly significant in the cyber context. There was something that you realize as soon as you start studying these issues, as I did when I first wrote my article a few years ago now. Indeed, someone defined cyberspace as one big masquerade ball. You can hide yourself behind botnets, hijack someone else's computers, spoof IPs, etc., etc. So these are just the most famous cases of interstate cyber operations. Estonia, Georgia, Stuxnet, cyber exploitation operations against the US, and the list could be longer, but I didn't add them all because it would be pointless and probably impossible. We can talk as long as we want about whether the victim states had the right to self-defense against the operations, whether they could adopt countermeasures, but if we do not know with sufficient confidence who did it, that becomes a bit like almost a theoretical exercise. So the evidence issue is somehow the elephant in the courtroom, because it is something that nobody really has discussed yet. However, it seems to me that it is the starting point of everything else. And as I said so far, the many articles and books that have addressed cyber operations, at least the state cyber operations, have somehow almost entirely, I think, neglected the evidence issue, and that's focused on whether cyber operations are consistent with the primary rules of international law and what the remedies are. We all know who the suspects are in these cases. I'll mention that just in case. Estonia and Georgia was the Russian Federation that was suspected of conducting this denial of service attacks. Stuxnet, Duke and Flame, an article in the New York Times a couple of years ago said that it was President Obama and President Bush behind it that started the campaign Operation Olympic Games, of which these three pieces of malware were part of. Cyber operations against the US, you know, the Mandian report, it says it's China. It says that unit in the People Liberation Armies, somewhere based in Shanghai. And Mike Schmidt mentioned the circumstantial evidence that suggests attribution of these operations, but it's nothing more than that. It is not forensic evidence, it is essentially circumstantial evidence. And the question is this enough? Is this enough to confidently attribute the operation to Russia, China, the US, Israel, so that, for instance, assuming that some of them are armed attacks, and assuming that probably most of them, if not all of them, are internationally wrongful acts, the target state, the injured state, can react in adopting countermeasures or reacting in self-defense. And that's the question that I will try to address in the little time I have, so I will just have to focus on certain points that are probably more interesting than others. Evidence is needed not to prove all the elements of an internationally wrongful act. So you will have to prove both the objective element, the violation of a norm of international law, and the subjective element, the fact that that violation is attributable to another state. Okay, so for instance, a state that claims the right to react in self-defense against cyber operations will have to prove that cyber operation actually occurred, and that it was targeted against that state. And also the fact that the cyber operation amounts to a use of force and reached the level, the scale and effects of an armed attack, as Mark was saying yesterday. So this is the first thing you need evidence for. Second, you need evidence to prove that that attack was attributable to a certain state, perhaps also to a non-state actor, if you believe that self-defense can also be exercised against a non-state actor. So evidence is needed not just for attribution, but also for the other element. For instance, in the case of Stuxnet, it is still not entirely clear if damage was caused by Stuxnet, and if so, to what extent. So we are not sure exactly whether that was a use of force in the first place, and if it was a use of force, whether it reached the level of gravity of an attack. We simply don't know. There are conflicting reports and conflicting versions. With regard to this evidence in relation to the subjective element, the peculiarity of cyber operations is perhaps the fact that you need evidence on three levels. First of all, you need evidence to prove that the attack originates from a certain machine, a certain computer system. Then you need evidence to prove that there was a certain individual behind it, who was the person behind it. And 3, you need evidence to prove the link between that individual and a certain state. Okay, so you need 3 levels of evidence. Which leads me to a point that evidentiary rules are different from attribution rules. Okay, evidentiary rules, standards of proof, burden of proof, etc., is different from the rules that establish attribution of the conduct of individuals or groups of individuals to a certain state. Standards of evidence of proof determine the quantum of evidence that you need to demonstrate, to have proof of a certain fact you claim. Attribution rules determine when the conduct of an individual or a group of individuals is attributable to a certain state. And the rules for the latter are contained in the articles that were adopted by the International Law Commission on State Responsibility in 2001. But to prove that link, effective control, overall control, for instance, which I believe Mike will talk about, you need evidence according to certain standards. This is what, for instance, the ICJ did in Nicaragua with regard to the Contras. There was no evidence, no sufficient evidence of an effective control exercised by the US over the Contras in relation to certain violations committed by the Contras. This evidence may be needed in relation to, it can be presented before the public opinion, if you want to gain support for something you want to do, say an armed operation, before a political organ, in order, for instance, to gain support and obtain the adoption of a favorable resolution. We all remember, for instance, the attempt to provide evidence before the Security Council to obtain a second resolution that would justify Operation Iraqi Freedom in 2003. Usually, however, evidence is submitted in places like this, in a courtroom, in the case of international litigation before an international court or tribunal. The problem is that unlike in domestic jurisdictions, there are no international law international law of evidence for international litigation. Certainly there is no, and I'm interested in Mike's thoughts on that. I'm not sure there are rules that prescribe a certain standard of proof in a political context. And I'm not sure that with regard to international litigation, you will not find an international code of evidence. Each tribunal determines its own evidentiary rules, not always in a consistent way, and even within the same tribunal, often different cases, similar cases, the same court adopts different standards. When the court eventually explains the standards that it adopts at all. So international courts work, at least in this sense, very differently from common law courts, and they are more similar to civil law courts, where the civil law judges do not really bother. They do not have to follow specific standards of evidence. They're convinced when they are convinced by the parties. So this is what I'm going to look at in the absence of a general set of rules, of a universal set of rules. I'll focus on the rules before the ICJ, which are contained in the ICJ statute, in the rules of the court, and in the practice directions first adopted by the court in 2001. Why the ICJ? Because, first of all, because it's the main UN judicial organ. Second, because it deals with state responsibility. And third, because it deals with all legal disputes. So it's not limited to certain disputes only. For instance, the International Tribunal of the Law of the Sea deals only with the violations of the Convention on the Law of the Sea. The ICJ potentially deals with any case of state responsibility. I will not look into evidentiary issues before international criminal courts, which have more developed evidentiary rules, by the way. But again, I will not be looking at issues of individual criminal responsibility, just state responsibility. And I will not look at evidence before domestic courts in relation to cyber crimes. The idea is to verify whether a set of rules with regard to evidence can be identified through reference to the ICJ case law in order to establish whether a claim of self-defense or of countermeasures against cyber operations is sufficiently grounded or not. So, there you go. So the first thing that comes to mind when you talk about evidence is who has the burden of proof, or which of the litigants has the burden of proving a certain fact. And the principle, which dates back to Roman times, and it's a general principle of law, and as such applied by the ICJ as well, is that one, the Latin principle, the onus probandi incumbit actoria. I did 5 years of Latin at high school, so anytime I have the chance to show it off, I love it. And there you'll see there are others, especially in this, in procedural law, they love Latin very much. The actor is not necessarily the applicant. In international litigation, distinguishing between the applicant and the respondent is not always easy. So the actor is essentially the litigant, be it the applicant or the respondent, that claims a certain fact. The party that claims a certain fact has the obligation, the onus of proving it. This principle, however, is limited, at least in 3 cases. Non-disputed facts by the parties do not need to be proved. Facts of public knowledge do not need to be proved. And I'll just say here, with regard to public knowledge, that obviously the very notion of public knowledge is an evolutive one. If you think now of the means we have, first of all, of course, the press, but then we had the internet, and nowadays we have the social networks like Twitter, etc. So what is public knowledge now, and how something can become public knowledge is perhaps different from what public knowledge and how public knowledge was formed 20, 30 years ago. And the third limit, again, Latin, is the jura novit curia principle. You do not need to provide evidence of the law. The judges know the law themselves. However, in international litigation, municipal law is a fact, so you have to prove it. And as far as customary international law is concerned, there is a tendency, the courts usually require the party to prove at least the special or regional custom. Why? Because one of the 2 elements of custom, state practice, is a factual one. So let's say that a party claims, invokes certain legislation on cyber issues, or the existence of a certain custom, cyber specific or not, in its favor, they will have to prove it before the court that that custom exists. Excuse me. The interesting point with regard to the burden of proof and cyber operation is whether the cyber context justifies a reversal of the burden of proof. This is something that I've read here and there in both secondary sources, articles, etc., but also in certain government statements. In particular, the claim is that in the cyber context, it's not the party that claims the right, for instance, of self-defense that has to prove that the other party, the party from which the attack originates, is responsible for that. It's the party from which the attack originates that has to demonstrate that it's not responsible, or that it exercised due diligence in order to stop it. So the burden will shift from the applicant, if you want, the claimant, to the other party. However, this is not probably an argument that would be well received by the court. If you look at one of the first cases of the ICJ, the Corfuciano case, in that case, the court made very clear that, and I quote, exclusive control exercised by the state over its territory neither involves prima facie responsibility nor shifts the burden of proof in relation to unlawful acts perpetrated therein. And I'm assuming that the state has exclusive control of the cyber infrastructure located on its territory. I believe it's Rule 1 of the Tallinn manual, right? So the court says that the fact that you have exclusive control of that territory and by analogy of that cyber infrastructure does not mean that you are the one that has to prove that you did everything that could have been done. However, the fact that you have that exclusive control may affect the standard of proof. That's something I'll come back later. This was said by the court not just in the Corfu Channel case, was said in DRC versus Uganda, was said in another case, Oil's platform. So it seems to be quite a jurisprudence constant of the ICJ in this sense. I've also read another claim with regard to the reversal of the burden of proof, which would derive from the application of the precautionary principle, which is usually applied in international environmental law to the cyber context. So I've read that the applying, well, first of all, the claim is that the precautionary principle applies in the cyber context. And as a consequence of this application, the shift would, again, be on the burden of proof will shift on the party that has to provide that has taken as early as possible all the precautionary measures to prevent that its cyber infrastructure is misused by others. But again, this is something that is not the approach of the ICJ. If you look at the pulp mills case, for instance, you will see that in that case, the court clearly said that the precautionary principle, it was obviously another context, not the cyber context, but applying it by analogy to the cyber context. In that case, the ICJ said that the precautionary principle may affect the interpretation and application of rules, but does not result in reversal of the burden of proof. It makes sense, after all, especially in the cyber context. If you think, as Mike was saying yesterday, that cyber operations are often, if not most of the, if not always, routed through several countries that don't just go like an arrow straight to the target. They take several diversions before reaching it, where you will have probably as many as possible states that will have the burden of proving that they actually exercised their due diligence requirements so that the the cyber infrastructure had not to prevent that their cyber infrastructure was misused by others. However, as I was saying, difficulties in discharging the burden of proof may lead to an alleviation of the standard of proof, again, according to the ICJ. You know that in common law jurisdictions, there is a rigid classification of standards of proof. That's from the most stringent to the least. This doesn't exist, as I said, in civil law jurisdictions where I come from, so I'm relatively out of my comfort zone here. Beyond reasonable doubt is usually is normally used by in criminal proceedings, and in fact it is applied also by international criminal courts. In civil litigation, it's usually the preponderance of evidence and the clear and convincing evidence, which is slightly more, they're not actually in order from the most stringent to the least, I have to say. The least would be beyond reasonable doubt, clear and convincing evidence, and preponderance of evidence. What is the standard of proof in relation to cyber operations? Well, the question is that in the ICJ statute, there is no, which takes, as I said, a civil law approach in this area. There is no, there's no indication of what the standards of proof the court should follow in the cases before it, and the ICJ has been quite inconsistent and has certainly not warned the parties before the trial or during the trial of what standard of proof it expects from them, which is of course a problem for the party that have to take certain risks. However, it has been suggested, and I agree, that there may be some indications that the court follows standards depending on what the substantive rules are the substantive rules being discussed in that particular case. In particular, for instance, in regard to jus ad bellum claims, the idea is that the court requires the party to use a clear and convincing evidence standard. This is language that is used by the court in Nicaragua, again, not entirely consistently, but in Nicaragua it's been used in the oil platform, it's been used in DRC versus Uganda, it's been used not just by the ICJ, it's been referred to also by the Ethiopia-Eritrea Commission in its jus ad bellum award. So there is this argument, as I said, that at least for jus ad bellum claims, and claims of self-defense, of course, are within them, you need to provide clear and convincing evidence of the facts involved. And clear and convincing evidence means more than probable. It's not just a balance of probabilities, it's more than that. It's not beyond reasonable doubt, but it's more than probable. The question in the cyber context, however, is whether this standard, assuming that it is correct, because that's open for discussion, would also apply, for instance, to jus ad bellum claims in relation to cyber operations amounting to the use of force. So again, the state that would that claims the exercise of self-defense against an armed attack by cyber means, does it have to meet this clear and convincing evidence standard, as it would, we assume, if the armed attack was conducted by kinetic means? That's the question. Or is there a lower standard? Because the argument is, as it is more difficult to identify the origin, to attribute the attack, well, then the standard should be lower. This is how the argument goes. The fact that it's difficult to identify and attribute, well, that means that you can alleviate these rules. I'm not convinced by this argument. I can't look, of course, at case law of the ICJ or of other tribunals, because there is none. What we can look at other contexts, like political or extrajudicial contexts anyway. And although there are some statements, as I said, that invoke this lowering of the burden of the standard of proof, I've found several, probably a majority of declarations in the opposite sense. I will just quote, for instance, a couple. There is the U.S. Air Force doctrine for cyberspace operation requires that the attribution of cyber operation should be established with sufficient confidence and verifiability. There is a report of an Italian parliamentary committee that says that the evidence that attribution must be demonstrated unequivocally. And it says actually even more, with irrefutable digital evidence. Similar language is used by Germany in a UK House of Lords document, in the Dutch report that Mike was quoting yesterday, and in the Dutch government's response to that report. So I'm not, again, this very brief and very incomplete survey of state practice, and also the fact that I find difficult, again, to accept that just because it's more difficult to discharge the standard of proof, it should be removed, or it should be reduced. After all, the standard of proof is not there to disadvantage the claimant. Is there to protect the defendant from specious or malicious claims, which is actually quite a high risk in cyberspace for the well-known issues. Having said that, just to mention the fact that according to the ICJ, charges of exceptional gravity, and I'm using the ICJ language, require more than clear and convincing evidence, but require fully conclusive evidence. This is language used by Judge Higgins in a separate opinion in all platforms. It's language used in the Corfu Channel case. It's language used in particular in the Bosnian genocide judgment. It seems that violations of peremptory norms of international law, jus cogens, international crimes, require higher standard of proof because they are so exceptionally serious. So again, by applying this reasoning by analogy in the cyber context, if the claim is of cyber operations amounting to war crimes or crimes against humanity or acts of genocide, those claims would have to be proved with probably fully conclusive evidence. It is interesting, however, that the ICJ distinguishes between, in the Bosnian genocide judgment, distinguishes between evidence needed in order to demonstrate a violation of the obligation not to commit acts of genocide, and the evidence needed to demonstrate the violation of the obligation to prevent acts of genocide. For the second one, the ICJ requires evidence of high certainty, if I'm quoting correctly, of a high level of certainty, but not necessarily fully conclusive. So it is still a very high standard of proof, but lower than a violation of the positive obligation not to conduct yourself acts, international crimes. Moving to the next test, I'm not sure how I'm doing with time.
You're about 2 minutes over.
Already? Oh, and I'm not even halfway. Mamma mia. No, I'm. My concept of time is very Italian, I have to say. Can I have 5?
You can take about 5, yeah.
Great. So very quickly, it's not just the standard of proof that you have to look at, it's also the means that you can use, the means of proof in order to meet that standard. And this is just a list of the possible options. Documentary evidence is favored by the ICJ, and there are a lot of documents that we could refer to in this context. Of course, I just want, as again I'm running late, I just want to mention that, for instance, documents, relevant documents may be cyber strategies, cyber legislations, military doctrines, rules of engagements. The problem is that the sensitive one, and probably the most important ones, will be likely classified. So what do we do? Well, not much, because the court does not have the power to order the production of the document to the litigants, which are states, they are sovereign states. What it can do, it can request the production of the document, and formal note, I quote from Article 49 of the ICJ Statute, formal note is taken of the refusal. This happened in at least one case, in the Corfu Channel case, when the United Kingdom refused to produce an admiralty order on grounds of naval secrecy. In another case, in the Bosnian genocide case, again, Serbia and Montenegro refused to produce certain documents on grounds of state secrecy. The court did not order the production of the documents and did not even draw inferences from the refusal of the parties involved to produce those classified. So it did not presume that the facts were true, or there was a likelihood that they were more true than not, because they were not produced. So we are not really well, how can I say, well off with this attitude of the court towards classified documents, which is very likely to arise, as I said, in the cyber context. And I just want to mention the other two documents which may be important. Yeah, there are others, of course, but non-governmental governments, the documents, there's a plethora of such documents, from the NATO Center of Excellence that prepares report on certain cyber incidents and others. From some of you will be familiar with the project Grey Goose in relation to the Georgia cyber operations, and the cyber security companies like Symantec and McAfee, etc., often produce reports after usually the events have taken place, which are usually a technical analysis of. However, the court has given much less probative value to these secondary sources than to official sources, like state documents or documents by international organizations, in particular the UN. What the court does is it looks at how the documents have been prepared. Factors that the court has, for instance, taken into account is the number of sources that they used, whether they were partisan or independent, the fact that they were interested or not in the proceedings, the relation of the reports to the event, the methodology used, their contemporaneity to the events. So the question is how rigorous, according to these and other factors, these documents are, and I'm not sure that all these documents that I've mentioned would pass this rigorous this analysis by the ICJ. As to press reports, again, the famous example is that David Sanger, I think, a New York Times article that revealed that Israel and the US were behind Stuxnet. How effective, what kind of probative value would that article have before the ICJ and perhaps before in other situations as well? Very little. Very little. The court has again denied probative value to press reports. So they, on their own, it said that they may be useful when they corroborate other facts, providing that they are wholly consistent and concordant as to the main facts and circumstances of the case. And they can be useful also to demonstrate public knowledge, but do not have probative value as such. So unfortunately for David Sanger, it's interesting reading, but the probative value is limited. And the fact that other articles appeared, says the court, does not necessarily increase the probative value, especially when they all derive from one single source. I'll just move on. The technical evidence, I'll skip it. And let me just say a couple of things on the fact that the exclusive territorial control, which I mentioned earlier, leads we said it doesn't lead to a shifting of the burden of the proof, but leads to an alleviation of the standard of proof. It says that the parties are allowed a more liberal recourse to inferences on facts and circumstantial evidence. This may be an important point in the cyber context. In the Corfu Channel case, even though the court said that the burden of proof did not shift from the UK to Albania because of Albania's control of the channel, still it coupled the exclusive control of the Corfu Channel by Albania with the silence of Albania with regard to the mines that were in the channel and other circumstantial evidence to conclude that Albania did know about the mine laying and therefore was responsible for that. So this is, I think, something that will have to be, may play some role in again establishing state responsibility in relation for attribution. However, the caveat is, is the court that says that, the caveat is that whenever evidence is based in this sense, on inferences and presumptions, it has to leave room to no reasonable doubt. So when we talk about indirect evidence, presumptions and inferences, the standard of proof is raised. It becomes no room for reasonable doubt. And finally, very, very last question, inadmissible evidence, is evidence illegally obtained in particular useful before the court? Cyber exploitation, data monitoring, interceptions may all be very useful, for instance, in establishing whether a certain state has conducted certain cyber activities, assuming, and this is certainly not uncontroversial, that these activities are internationally wrongful acts. Is the evidence collected through cyber exploitation, through data interceptions and monitoring, can it be used? Does it have any probative value, for instance, before the ICJ? The answer is yes. The answer is yes. There's no rule in the statute that says that inadmissible evidence includes that obtained illegally, as there is, I believe, in the US system. In the UA, again, in the Corfu Channel case, the UK collected evidence illegally. The court said that the operation was illegal and did not become legal because the purpose was to collect evidence, but did use the evidence so collected and did take that into account. I think I'll stop here as I've already abused my time, so I'll leave the rest perhaps for the Q&A.
Well, I think I'll begin just by briefly answering Marco's question, because it was a very interesting question. And the question is there a difference between the standards that would apply in a tribunal, for example, in a judicial setting, and the standards that would apply in the political setting? And we actually, it's interesting because we were in Tallinn 2 weeks ago and we were talking about these very issues. So I happen to have the draft text, which we worked on, and I'll read it to you. We took a very practical approach because our question was less one of what's the judicial standard than what do you do if you're a state? you're a state and stuff is happening to you, and you're wondering, can I respond to this stuff? Do I have enough evidence to believe that it's attributable to a particular state or not? So I'll just read you, it's relatively brief. A related question is the required level of certainty that the state is involved to the level of attribution. This question is essential in the context of cyber operations because states will often be in a situation where, as a practical matter, they have to decide on appropriate responses to cyber operations conducted by non-state actors that they suspect are attributable to a state. The law in this area is unsettled. Whenever you write anything, always put that sentence in. It's a saving clause. The law in this area is unsettled. In particular, there is no standard of proof that is particular to the law of state responsibility. Here, therefore, the assessment of whether the attribution of a non-state actor's cyber operations to one state by another will be governed by those principles applicable generally in international law. In principle, the graver the underlying breach, the greater the confidence must be in the evidence relied upon. This is because the robustness of permissible responses grows symmetrically with a breach's seriousness. So, what does that mean? It means that your state, and you're taking cyber hits, and you want to respond to those cyber hits. Well, you have a range of options available to you. You can engage in unfriendly acts, retorsion, that's at a fairly low level. You can engage in countermeasures, which are actions that would otherwise be unlawful, but for the offending states, the responsible states' internationally wrongful act. Or you could engage in self-defense because the act rises to the level of an armed attack. That allows you to use force. And what we basically say is you have to be sensitive to the fact that that's a graduated response. So if you want to respond down here, that would require perhaps a lesser level of certainty than replying with the use of force, which would require a higher level of certainty. So it's sort of a sliding scale. We then talk about an arbitration, or I'm sorry, not an arbitration, the Iran-United States Claims Tribunal case of Yeager versus Iran. We cite the fact that they mention reasonable certainty. We cite the fact that the International Law Commission also cited Yeager in the Articles of State Responsibility. And then we come to what I believe is in fact the law. We say ultimately the uncertainty has to the requisite standard of proof for attribution of a non-state actor's activities to a state leaves states with a general requirement in international law to act as reasonable states would in same or similar circumstances. And so for us, that's what we said, not with regard to what's going to happen in a tribunal or an arbitral panel, but rather what's going to happen in a command center. You know, we want to respond. Can we respond? Well, what do you know about the attacks? Ultimately, it's about reasonableness, which is true generally in international law. So, at any rate. So let's talk about, oh, good, thank you.
Yes.
Let's talk a little bit, I'm going to come out here so I can actually see the slides. It's on the desktop. Also because I noticed that you all are sitting back there, and I'm not really sure, because yesterday you were sitting here, and after having experienced last night's lecture, now you're all sitting back there, and I'm not sure what to make of this. But at any rate, let me come out here and talk to you about the law of attribution in cyberspace. If we're talking about the law of attribution, we need to be very careful to distinguish attribution for the various purposes that attribution can be had for. For example, you can have attribution for the purposes of state responsibility to determine that that cyber act is the responsibility of that state is responsible for it. You can have attribution for the purposes of self-defense. So state A, the question is whether or not a cyber operation is attributable to state A, such that state B, the victim of the operation, can respond with its own use of force pursuant to Article 51 of the UN Charter. And then finally, we have attribution for the purposes of international humanitarian law, and that's determining whether or not we have an international armed conflict between two states. So, for example, non-state actors are attacking my state. I have to ask, are the actions of the non-state actors attributable to a state such that now we have an armed conflict between state A and state B, the state responsible for the actions of the non-state actors. So when we talk attribution, we need to be very, very, very careful to start with the question of attribution for what purpose. So let me start with the law of state responsibility, which is the subject of the panel. And by the way, we're only talking about two aspects of the law of state responsibility, but in the Q&A session, if you want to talk about countermeasures or other issues, I think Marco and I would probably be happy to talk about that as well. So why are you looking at attribution for the purpose of state responsibility? You're looking at it for two reasons. The first reason is to say that state did something wrong. That state committed an internationally wrongful act. It's to go into court or to go into an arbitration and say that state's responsible and therefore the consequences should lie with that state. That state's bad. Okay? The second reason is the one that is much more interesting to those of us who are working on the TILJ manual, the TILJ03 project, and that's, well, why do you need state responsibility? You need it because I need to be able to respond to the activity. So my responses are driven by whether or not I can attribute the act to a particular state. Now, there are two factors that are relevant here. One is reparations. In other words, if I can attribute the cyber operations to a state, and those cyber operations constituted an internationally wrongful act that caused me harm, then I may be able to get reparations. I may be able to make whole for that activity. We're marginally interested in that, but what we're really, really interested in is the other bullet, and that's countermeasures. Because unless you get to the level of an armed attack, unless the cyber action rises to the level of an armed attack under Article 51, you can't respond robustly with the use of force. And so you're going to be limited to something called countermeasures. What are countermeasures? Well, countermeasures are actions you take below the level of use of force that would be wrongful, would be an internationally wrongful act, but for the internationally wrongful act to which you responded. And why is this important in cyberspace? It's super important in cyberspace because I may be taking cyber attacks that don't rise to that high level, armed attack, but I want to respond. In fact, I want to hack back. But normally, if my hack back operation would be wrongful, I couldn't do it. And so what the law of countermeasures does is it precludes the wrongfulness of my response. So we're very, very, very interested in attribution. The reason is we want to know when we can take countermeasures in response against the state that is responsible for the action. Now, the easiest case of attribution is when the operations are conducted, the cyber operations are conducted by state organs. These are the regular entities of the state. I've got the ones that are most relevant here in the United States up on the slide. Of course, the United States Cyber Command, which has offensive capabilities. The National Security Agency, which has capabilities that seem to be growing every day. And of course, Homeland Security, which is responsible to some extent for the defense of the cyber infrastructure. And there are many, many, many other agencies that are involved in cyber operations. The rule is a pretty simple one. If you're an entity of the state, if you're the U.S. government, then the state is responsible for the actions of that entity and all the people associated with that entity. Now, there are some risks here, some practical risks. I don't want to go into them. Marco mentioned them briefly as well. There are some practical risks, and the practical risk is that in cyberspace, it's kind of different than a lot of other areas of activity because cyber operations unfold very, very, very rapidly. I mean, literally, they're happening in milliseconds. And you may need to, if you want to be effective, you may need to respond right away. And there are risks, for example, that the origin of the offensive cyber operation, the malicious cyber operation, will be spoofed. For example, someone may have PMW a computer. PMW means they take over a computer. It's actually interesting. It's actually owned, not PMW, PWN. It's actually owned. Someone was typing and they said, I own your computer, okay? But when the wirehead was typing, he hit P instead of O. So PWN actually means own. So I own Derek's computer. But I will make it look like Derek is conducting the operation. So when we're talking about attribution by virtue of state actions, it's entirely possible that a government computer has been taken over by someone to make it appear as if the state is actually conducting the operation. And then there are also risks of simply technical misattribution. By the way, in the Georgian case, the Georgian and to a lesser extent the case of Estonia that I talked about last night, there were actually attacks that were conducted from Russian government computers. But because of the possibility that those were taken over, you could not attribute with sufficient reliability to say the Russians are responsible for these attacks. Okay. Because of this problem, we talk a little tiny bit in the TILJ manual, something Marco mentioned, and that had to do with what about the cyber infrastructure being used. You see, I mean, I come from the Naval War College. If a warship shoots at you, okay, big gray ship, cannons on, you can be pretty darn sure that the state's responsible for that action. So with international law, generally, we usually said that, well, if it's a state entity involved, and the U.S. Army M1A1 tank, the chances are the United States is responsible for that action. However, cyberspace is different because of this technical capability. So we said in the TILJ manual, in a rule that will simply become commentary in TILJ 2.0, we said, listen, if you're using government cyber infrastructure as distinct from private cyber infrastructure, then that is an indication that the state is involved. But because of the unique technologies involved in cyber activities, that's not dispositive. It's not like the M1A1 tank or the warship. We also talked a little bit about the fact that private cyber infrastructure located on a state's territory is used, and we said the fact that private cyber infrastructure on a state's territory is used is not an indication, absent more, that the state is responsible for the particular action. And the same is true with regard to cyber infrastructure through which an operation is routed. If you have a server on your territory and an operation is routed through that server, that's not an indication that the state is responsible. Now, we're not simply talking, when we talk about state organs, we're not simply talking about organs that are actually formally a part of the government. There is another circumstance in which an entity will be treated as a state organ for the purposes of state responsibility, and that's where the state has in some way empowered the entity, the organization, the company, to perform elements of government authority. In other words, that entity is doing something that governments normally do. You would expect to see a government agency doing that. So I've given two examples that we chatted about a couple weeks ago up here. You have a contract with a private sector CERT, a computer emergency response team, an entity that's sort of responsible for safeguarding and responding to computer incidents. You have a contract with a private sector CERT to protect specifically state activities, like the United States Naval War College. Okay, we have our own guys that do this kind of stuff. However, we could contract with a private firm to protect our U.S. military assets. That would be exercise of government authority, an element of government authority. The second example is actually very realistic in today's environment. That's where you outsource offensive cyber operations to a company. You're a state, you don't have your own set of cyber capabilities, so you come to America, you hire some outfit to conduct offensive cyber operations for you. Normally, conducting such operations, engaging in uses of force and so forth against other states, that would be an activity that's reserved to the state. So if you go and you outsource state activities to private concerns, then those activities are treated just as if they were conducted by the CIA, the National Security Council Agency, U.S. Cybercom, and so forth. Now, the attribution of the activities of state organs is unique, and it's unique because of this last bullet. If we're talking about state organs, either real state organs or state organs that are exercising elements of government authority, then everything they do is attributable to the state. Everything they do, including acts that are ultra-virus. So, in other words, unauthorized. Not only unauthorized, but specifically against the instructions of the government. So, for example, if we take the CERT, which we mentioned up here, and the state tells the CERT, hey, don't do these things, and the folks in the CERT actually do those things, then those activities, if they're internationally wrongful acts, will be attributable to the state. It will be as if the state conducted them. This is very important, and it differs from the acts of non-state actors that I'll show you in a moment. Sometimes you are responsible, the state is responsible for the activities that are conducted by other states. So we have first, states responsible for the activities of its organs. Sometimes a state is also responsible for the activities of other states if those activities are internationally wrongful. And there are three circumstances, only two of which are important. The first is where one state is helping out in the commission of an internationally wrongful cyber act, an unlawful act in cyberspace, and the state that's helping out knows what's going on, okay? And if the state which is helping out had done the activity itself, it would have been wrongful vis-a-vis the other state, which we call state responsibility to the other state. So the example up here is state A is attacking state B, but state A is using state C's infrastructure, my cyber infrastructure, to attack state B. I will be responsible. I am helping out. I will be responsible as if I had conducted the attack as well. So both state A and state C are now responsible pursuant to the law of state responsibility, and this opens the door to responses by the injured state against not only state A, but against state C. Okay, so this is very important. The second example is not important. It's where one state directs and controls the activities of another state. The level of control is very, 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 very high. And when we talked about this, we kind of wrote it out of the manual, except for cases of occupation. When you're in occupation of another state, you can really direct and control everything they do. That would probably be the only case. The third case is somewhat more likely, and that's where one state coerces another state to commit an act. If state A coerces me to intrude into the computer systems of state C, for example, but because it threatens me, and so that's why I do that, and this act is internationally wrongful in breach of treaty, in breach of customary law, in breach of the principle of sovereignty, in breach of the principle of intervention, non-intervention, et cetera, et cetera, et cetera, then both states will be responsible for the offending act. Now, all of that's interesting, but this is what people care about. And it's the action of non-state actors because, as you probably know, the world is full of individual hacktivists, individual malicious hackers, hacker groups, hacktivist groups, et cetera, et cetera, et cetera. And so the big question here is, when is the state responsible for the actions of a non-state group or of individuals? This was, of course, the big question in 2007 in this country. Were the Russians, was Russia, the state of Russia, responsible for the actions of all those hackers that attacked this internet? It is, of course, the big question with regard to Georgia. Was Russia, as a state, responsible for all those actions? And it is, of course, the big question right now with respect to the activities being conducted primarily against Ukraine, but by the way, the other way as well. I mean, there are Ukrainian hackers hacking back into Russia. So is Ukraine responsible for those individuals and those groups that are hacking against Russia, and are vice versa with regard to the Russians? So this is the big question. There are three circumstances in which a state will be responsible for the actions of a non-state actor, of a group. The first two are here. The first one is where the non-state group is acting on the instructions of the state. Now, this is a little bit different than what I talked to you about previously, where you're exercising elements of government control. Because in that circumstance, you're doing what states normally do. So instead of the state having an agency, they hire you to perform that function. This is different. This is not where you're performing the element of government authority, but the state is generally instructing you to perform certain activities. The example I gave up here is you have a hacker group, they're always going into systems and so forth. So the state connects with the hacker group and says, hey, when you guys are out there, we want you to look for vulnerabilities in these types of systems and let us know. And so the hacker group provides that information back to the state, and then the state exploits those activities. That's different from the second way a non-state group can be, actions of a non-state group can be attributed to a state. And that's where the state exercises direction and control over the non-state group. Now let me explain the difference. This is really where the legal term is, where there is effective control over the group. It's where the group is acting on the state's behalf. It's where the state says, go do this. So in the first case, what we're really doing, instruction control, we're kind of outsourcing an activity to the group. You guys search for vulnerabilities, okay? In the second case, direction and control, what we're saying to the group is go attack that particular cyber target, okay? In either case, the actions of the groups will be attributable to the state such that your responses can be against the state itself. Direction and control is basically, we came up with this term, this is not law, but we came up with the term, it's determining the execution of the course of a particular cyber operation. For a number of reasons, we were able to exclude simply providing financial support and providing malware to non-state groups. Now, you need to be careful. When we put in the manual that it doesn't include providing malware and financial support, that doesn't mean it's okay to provide malware or to provide financial support. It simply means that if you're paying for an operation or you're providing malware, you won't be responsible for the operation itself, but you may be responsible for your wrongful conduct in financing the operation. Okay, see the difference? Now, the third way that you can be, your acts can be attributed to the state, if you're a non-state group, is where the state retroactively acknowledges and adopts the action. This comes from a very famous case, the Iran hostages ICJ case. And so what happens in this case is the state looks out there, they see a non-state group engaged in malicious cyber activities, and they say, not only it's good, but hey, that's good, and we'd kind of like to help you out. So for example, in the example I have up here, it's the state says, hey, that's good, we're glad you're attacking that other state, and maybe we can lend a hand. For example, we'll provide you cyber defenses. In other words, if they start to counterattack in cyberspace against your group, we'll use our assets to help you out to protect that, to protect your activities that are ongoing. So it's more than simply saying, that's great. It's more than Russia saying, well, you know, those Estonians, they really angered us as well. Or the Russians saying, you know, Georgians, those guys are crazy. They should never have tried to take back South Ossetia. Okay? So it's more than mere encouragement. It's really saying, that's great, we'd like this activity to be our activity, and we'll provide some assistance. Incidental and peripheral association is not sufficient for attribution. We talked last night about the cases of Estonia and Georgia. We're watching the cases of the Ukraine. I haven't seen anything so far, watching the traffic on the Ukraine, that lead me to believe that we could attribute the actions of the hacktivists that are involved on both sides of the conflict to either state yet. Okay? Clearly yet. And then there was the interesting case of the Syrian Electronic Army. There's this group in Syria affiliated with the Assad government, and they conducted a very interesting operation using the Associated Press's Twitter feed, where they basically said there had been a bomb at the White House and Obama had been injured. And of course, the stock market was momentarily, you know, kind of crashed momentarily. There's an operation that was clearly in support of Assad, clearly in support of the government of Syria, but attribution would not attach because we don't have any evidence that that group, the Syrian Electronic Army, was either acting under the instructions or under the direction, control, the effective control of the Syrian government. Geography, this is easy. The role of geography and attribution of non-state actors is easy. It doesn't count. It's completely irrelevant. It doesn't matter where the non-state actors are operating from. They do not need to be operating from your territory. In fact, in many, many cases, they will not be operating from your territory. That's irrelevant. The only thing that matters is how in control of their operations are you. And then we mentioned also Virus Acts with regard to state organs. The state, you're responsible for everything bad those people do, even if it's against your instructions, counter to your instructions. That's not true here. In the case of non-state actors, there's no ultra-virus doctrine. In other words, if they go against your commands, then you are not responsible for those actions. And the classic case would be in the kinetic world and in the cyber world, we create target lists. So we say, attack these targets. You're in effective control. Remember with Professor Jenks, I'm in effective control of Professor Jenks. So I say, Derek, attack these targets. So he attacks those targets, but he also attacks a few others. I'm responsible for the targets he attacked, but I am not responsible, the state is not responsible for the targets he attacked pursuant to my instructions, but I'm not responsible for the attacks on those other targets. And this is an important distinction because you're dealing with groups that are difficult to control. Indeed, they may exist only virtually. So this is an important distinction. Okay, state responsibility to decide. There were two other areas where attribution is important. Remember, state responsibility is about asking the question, I see some actions over here. Can I hold that state responsible? Can I say you're a lawbreaker? And if they're hurting me, can I take countermeasures and demand reparations? That's state responsibility. Okay? Now we're in the realm of self-defense, and the question here is different. The question is, I'm suffering cyber operations, malicious, harmful cyber operations. And what I want to do is I want to shoot back. I want to shoot back with electrons, or I want to shoot back kinetically against whoever's responsible, against the state. Okay? And the question here is, if I see these activities over there, and they're conducted by a non-state actor, can I treat it as if that state, which is affiliated, had attacked me? Such that when I respond perhaps against the non-state actors, but I respond against the state itself. So it's a very, very, very important question. Of course, when I talk about this, I assume you know that there are lots of requirements for self-defense. So it's not sufficient to just say, you know, this non-state group was controlled by this state. Okay, that's enough. Let's start shooting cruise missiles at them. I mean, there are all sorts of requirements, necessity, proportionality, requirements with regard to timing called imminency and immediacy. Assume for the sake of argument you've met all of these requirements. And now the question is, they're attacking me, can I shoot at the state that's affiliated? This was a question that was addressed in the very famous Nicaragua case, also called paramilitary activities, formerly called paramilitary activities. And there the court had this to say. An armed attack includes sending by or on behalf of a state armed bands and so forth to carry out essentially armed attacks with a substantial involvement therein. When you look at this standard, sending by or on behalf, that's an awful lot like the effective control standard that we talked about in terms of the law of state responsibility, where I say, go do this. We concluded that that's probably an appropriate standard in the law of self-defense. That's an easy way of expressing it. It's not the way the court expressed it. The court used the term effective control in a different context, but we said effectively that captures the concept we're trying to express here. The substantial involvement comment by the court often causes confusion because it seems to be saying, on the one hand, okay, you've got to tell those guys to go do it, or you've got to be involved. It's like, what? I mean, what's the level of involvement? Basically, what we said here is it's a joint cyber operation. So we have our non-state group over here, we have our state over here. Maybe you're conducting the execution of the attacks, but you're providing malware and target sets, you're talking to each other, you're coordinating, you're jointly conducting the operation. And we said that that would be substantial involvement such that when I start taking hits from you guys, I can shoot at Professor Jenks. Financing, providing malware, we held was insufficient to rise this level. Again, that's based on Nicaragua, which said that financing and providing weapons was insufficient, and so therefore providing malware would be insufficient as well. I would caution you, the mere fact that something isn't necessarily attributable to a state, pursuant to the law of self-defense, doesn't mean that the state isn't responsible for violating the principle of non-intervention. As I mentioned last night, Professor Watts is our expert on that. You can ask him those questions. But it's one thing to say, okay, you guys are attacking me and I want to shoot at Professor Jenks. That's the law of self-defense. But if he's financing you and then you're involved in my country, he may be responsible for not the unlawful use of force that rises to the level that permits him to shoot back. He may be responsible for intervening in my affairs. But this is a different body of law that has different issues. I just wanted to alert you to that possibility. And then finally, the last thing I wanted to talk about was attribution for the purposes of finding that there's an armed conflict. This is very, very important because when there's an armed conflict underway, then a whole new body of law called international humanitarian law kicks in. And here we're talking about conflict between states, because we're trying to attribute the actions of the non-state actor to a state. And so we're talking about international armed conflict, and that's where the greatest amount of international humanitarian law applies. All the rules on targeting, detention, protection of medical personnel, activities, et cetera, et cetera, et cetera, all kick in once we have an international armed conflict between state A and state B. So the question we want to ask now, and it's very, very important because, for example, once we have an international armed conflict, I can target people in this country based solely on their status. They're in the military, they're targets. As they sleep, as they're on vacation with their spouses on the beach, I can kill them, okay? So it's very important stuff to ask the question, is there an international armed conflict? So what we're asking here is, you guys are doing stuff to me. Is the stuff you do to me, does that create a state of international armed conflict between the two states? This was a question addressed in the TILJ opinion, very first judgment by the International Criminal Tribunal for Yugoslavia, for the former Yugoslavia. The appeals chamber addressed it, and what they said there is we're not really going to apply the effective control test. Remember, that's specific control. That's controlling specific operations. We're applying a slightly different test that we're going to call the overall control test. It's a lower level than effective control. And they give the example of participating in planning and supervising military operations. So it's not so much, remember earlier I was telling Professor Jinks, go attack these targets. It's not like that. That's effective control. It's more, okay, we need to create an operation. We need to address a particular target set. I think this malware is going to be the most effective. In other words, we're working together to plan the operation that he eventually conducts. Again, financing cyber operation providing malware is not sufficient to create an armed conflict between two states. So this is a slightly different standard. It is a lower standard. It's used for a different purpose. It comes from a different body of law. I would say that this standard has created some confusion because you had Nicaragua, the International Court of Justice, saying effective control. Then you have TILJ talking about overall control. There's been lots and lots and lots of confusion. Don't be confused anymore. Everyone agrees now there are different tests for different purposes emanating from different bodies of law. This was recognized in the genocide case, which specifically said overall control for IHL, classification of conflict, effective control for state responsibility. There is one tiny, tiny difference that an awful lot of people miss. And that's that when we talk about overall control, we're talking about a group, okay, an organized armed group. We're not talking about an individual. If we want to attribute the actions of an individual, which is very likely in cyberspace, by the way, we have to then meet that higher threshold effective control. So if state A is controlling, is working with a group, all we need is overall control for there to be an armed conflict between us. But if state A is working with a single individual who's conducting cyber attacks against me, then state A needs to be saying, go attack specific targets and so forth, before her actions will create an international armed conflict between the two of us. And with that, I think we'll go ahead and take questions now.
Yes, great.
And I would say, again, if you want to talk about countermeasures and so forth, that's okay. We'll be happy to do that. Could you identify yourself, please?
Hi, I'm Derek Jenks. Thank you both for really terrific presentations. I'm simply curious, Marco, if you might react to Mike's opening comments on the current Tallinn approach to the standard of proof. It is an interesting series of questions. There are two pieces there, I suppose. One is the institutional point about whether we really ought to be asking ourselves what the appropriate standard ought to be in the ICJ or some other international tribunal, or whether we really ought to be talking in more of a trans-institutional way about what the level of proof ought to be. And then the second piece is the level of proof itself, this idea of acting reasonably, depending on the circumstances, a kind of good faith and reasonability sort of requirement, which I was very interested to hear you make that point because it's exactly what was occurring to me as you were discussing ICJ approaches. I thought that operators and other and commanders are very likely to take a different approach, something very much like what Mike described. So I hope to get your reaction to that approach.
Shall I answer immediately, or how are we proceeding? Yeah. Yeah, as I said, I mean, I focused on how can I say, on the judicial context. What I think I can confidently say is that, yes, there is no specific rule on evidence in an extrajudicial context. I think there is actually one treaty, I can't remember which one, that says something about it, but I don't remember. And that there is issues of evidence in arms control treaties, but let's leave them aside. But there may be evidentiary consequences from the application of general principles, like the principles of reasonableness. I still wonder, however, I think I'll answer a question with a question, which is probably not the best way of doing it. But I wonder whether don't we have to somehow substantiate this reasonable approach somehow? I don't know, we identify certain factors, then make, because at the end of the day, that commander will think, okay, I have to act reasonably, but what does that mean? If I haven't, if there are some, like I have to do this, in theory, it would be better if I do that as well, and if I can't do that, I should do that. I don't know, perhaps something like going step by step through different possible options. Otherwise, I don't know, it's like the reasonable military commander. I mean, at the end of the day, it's nice language, but I'm not sure it helps the making the decision. It does, but up to a certain point. And also, you're right that you say, okay, this is the judicial and this is the let's say, the extrajudicial political environment. We have to think of the military commander that acts in an extrajudicial context. However, that the commander will also have to take into account the fact that the case may end up before a court, right? So it will also, I think, of course, he can take into account that the reasonable principle, but what if I go or my state goes before it? That the Nicaragua case was all about that. And the others, the DRC. So it's not unlikely that even in cases of use of force end up before the ICJ. So I think even in a political context, a political decision may end up having legal consequences established by a court. And it could be actually be two phases of the same dispute, again, as in Nicaragua. So yeah, I don't think it answers completely your question, but I think this is exactly where I think more work needs to be done. It's a very interesting area, I think.
Yeah, I think we need to be very careful about distinguishing between primary and secondary rules, as you correctly said, Marco. I thought it was a very important point. Let's take the commander, okay? Let's use the example of the commander, and we'll cyberize it. A commander at U.S. Cybercom that's responsible for responding to an event that is unfolding very, very quickly. I think reasonableness is an appropriate standard. I mean, the reason is because almost every event is going to be a lot different. If you've ever been in armed conflict, you know that no situation ever repeats itself on the battle space. Never, never, never. It's always somehow different. So I think you can't ask more of a commander than to be reasonable. However, that's a very different question than what happens in court. You're exactly right, Marco. When you get in court, though, you will apply evidentiary standards, but evidentiary standards has to what? Has to whether or not that guy acted reasonably. So the standard remains the same, but the evidentiary standard necessary to demonstrate that that person has in some way violated the requirement is different. So it's, you know, we were talking, Marco and I, because I'm very, very, very interested in this work. It's very important to what we're doing. And so I gave the example of I'm walking in the streets of Austin. It's late at night, okay? Coming down the street is a very scary looking guy. We'll call him Derek, okay? It's late at night, I'm all alone. And as he approaches me, he does a motion that scares me, that frightens me, and I think he's about to attack me, so I strike him, okay? Now, the question there is the reasonableness of my belief that he was assaulting me, and I needed to defend myself. That standard is very different than he is now arrested by the Austin police and taken into court and charged with attempted assault. There you apply a different standard. So I think the same is very much true in cyberspace. We apply a different standard to to assessing the responses of states to potential actions than to now you're before an arbitration and you have to demonstrate that that state really did breach an obligation owed me, really did commit an internationally wrongful act such that I've suffered harm and deserve reparations. But this is at least just my view.
Yeah, just when you were saying something, I remembered something that actually is somewhere in my presentation, but I didn't have the time to say. But the ICJ, which is, yes, takes very much the comfortable court approach, but it even says in, I think it's still the Corfu channel, that even they don't see anything special in the situation of armed conflict as far as evidence is concerned. It's not more difficult to collect evidence in armed conflict than it is in other situations. Therefore, they don't see any reason why the rules should be different. Reversal of the burden of proof, alleviate the standard of proof. So they say you can do that when it is exclusive control of territory and it's impossible for the other party to actually have access. But in a situation of armed conflict, yes, of course, it's difficult, but yeah, it's just another case. So whether this is right or not, whether this is, or they are in touch with reality, okay, I'll leave the question mark there.
Other questions? Sorry, I should bring that.
I'm recalling the same conversations that Mike was recollecting a moment ago at our last meeting in Tallinn, and it shocked me how difficult this issue was. I thought it was going to be easy and we would dispose of it quickly. The first difficult point was one I thought that, Marco, that you illustrated very well, and that was how elusive the evidentiary standards of the ICJ are, that they are very much a floating standard. You can't find them in their statute. They're not in any rules of court. They're not particularly well developed in their jurisprudence. They seem to have retained a lot of discretion on that matter. But the more interesting purposes, or interesting question for our purposes in writing the manual, was to try to figure out whether there is a freestanding international violation by a state that doesn't observe, when that state doesn't observe or meet an evidentiary burden prior to acting. And the interesting hypothetical that I thought of on the plane ride home was, what if a state acts very rashly? What if a state suffers cyber consequences, acts very rashly, against the entity that it appears for the moment is the source of those obligations, but everyone would agree that that was rash and even, let's say, unreasonable on their part. But they get lucky and it actually was right. Was their rash action itself a violation of international law? The best source I could come up with, again with a pretty skeptical eye toward international rules generally, was what you mentioned a moment ago, Marco, general principles of international law. Can we say that as a matter of general principles, the states have a general obligation to act reasonably, as I think we agreed in the language that Mike quoted to everyone earlier in his presentation. But hearing it again when he read it, Mike will love me for this, hearing it again when he read it, though, I was still feeling a bit skeptical about our claim that there is an affirmative duty in international law for states to act reasonably. Do you have reflections on that or thoughts on that?
No, I don't believe that's the case at all, Sean. I don't believe I don't believe a state violates an obligation owed to other states by acting unreasonably or rashly. What I'm saying is if the allegation is that you have breached an obligation.
It's not a primary obligation then, right?
So it's the situation where I launched the countermeasures, but it turns out that it was not. In fact, you were not. So long as I've acted reasonably, I think then there's no breach of obligation there, or it's precluded. But I don't think there's any duty in international law that requires states to act rationally all the time. I mean, pick up the New York Times and you'll find that if this is the case, we're in big trouble. You know.
Marco, would you agree?
I agree. I mean, I struggle to see a primary obligation to act reasonably or not in a rushed way. I wonder, I mean, let's say that a state rushes to self-defense and let's say that it's wrong, right? The action itself is illegal. Assuming that there is such an obligation, it will be absorbed in the main violation, which is the violation of Article 2, Paragraph 4. Who will think of the violation of the prohibition to act unreasonably? Nobody, right? It will be absorbed in the, and but also I can't really see, but I keep my mind open with regard to that, because I don't think we are at the end of it. I think there's a lot to think about in this area, which is extremely interesting. Unless, when you were saying that, I thought, okay, unless there is such a primary obligation not to rush to certain actions in specific cases, in specific instances. For instance, it's a treaty obligation. I was thinking perhaps that something like in IHL Article 57, you do the precautions, right? In that case, you have to act reasonably, in that sense, reasonably taking all the active and passive precautions. But unless there is no such obligation applied to specific cases, I can't see it, I think.
I agree.
All right, at that, we will take a 15-minute break. You can get some coffee, and then we'll come back to the second panel.
This was absolutely fascinating.